Red button down. Can you hear me?
First of all, thank you, Dan. Any questions of Dan before Chris and Adam proceed? Okay. Chris, all yours.
Thank you. Thank you, Dan. Thank you, Mr. Chair. Thank you, members. I'm here, a privilege and honor to introduce to you once again your crack legal intern, Adam Borchard. Done fabulous work for me, for the staff, for you, council members. Today happens to be his last day in the office, and so I wanted to recognize him in front of you, and hopefully you can do the same. I also wanted to thank McGeorge, the law school from which he hails and still attends, Colleen Truden, who runs the extern internship program, fantastic in offering up fine candidates like Adam for us over the last 3 years. In fact, we have another Adam, a friend of this Adam's, that will begin with us in about 3 weeks, Adam Silva, who will be taking Adam Borchard's place. But at any event, Adam's done a fabulous job. I wanted him to give one last final legal update for your benefit on a non-Delta plan case. And there are many still out there. And you've been reading about some of them in the press. So with that, I'd like to turn it over to Adam, and he can not only give the update, but show off the latest fashion in body armor that he's sporting on his left hand.
Thank you, Chris. Chris is referring to my book.
Red button down.
Is that better?
That's better.
All right. Thank you, Chris. Mr. Chair, members of the board. The issue I want to talk to you today about is a case that the Ninth Circuit came out on April 16th. It's Natural Resources Defense Council v. Jewell. You may have heard of a previous case last month. It's similar issues, but not quite. It was a consolidated Delta smelt case, and that concerned the 2008 biological opinion. This, although it relates to the 2008 biological opinion, its main focus is on the renewal of contracts with the Bureau and the Central Valley Project. In 2009, Judge Wanger of the U.S. District Court for the Eastern District of California came up with a decision that affirmed the Bureau's position on renewal of these contracts. The contracts that were of issue in this case were contracts with the Sacramento River settlement contractors and also another subgroup with the Delta Mendota Canal. Concerning the Sacramento River settlement contractors, these were senior water rights holders to the Sacramento River. Their water rights to the Sacramento River predated construction of the Central Valley Project and construction of Shasta Dam. A lot of these actually go back to the 1800s, which of course is well before the construction of Shasta Dam back in the 1940s. The Bureau in 1964 had settled with these water rights holders. In exchange for their water rights, they were given contracts to CVP Water amounting to 2.2 million acre feet. So those are the contracts that are at issue in this case. So in 2009, Judge Wanger came out with the decision that affirmed the Bureau's position that didn't have to go through ESA Section 7 consultation with the Fish and Wildlife Service. In 2012, the Ninth Circuit in a 2-1 decision affirmed Judge Wanger's decision. NRDC then appealed to an en banc hearing by a full panel of the Ninth Circuit. And then on April 16th of this year, an 11-0 decision, the Ninth Circuit reversed Judge Wanger's decision, basically said that the Bureau had to consult with the Fish and Wildlife Service according to Section 7 of the Endangered Species Act concerning the Delta smelt. And there were two technical issues that the court decided before addressing the substantive issue of whether there was any federal discretion in renewal of these contracts. On the issues of standing and muteness, the court basically affirmed or basically sided with NRDC on both issues. It said that that the case was not moot because the NRDC was seeking relief that the court could provide, and that was not already provided by the 2008 biological opinion. And on the issue of standing, that NRDC did have standing. Now, on the substantive issue of discretion, Judge Wanger of the district court said that because of the terms of the contracts, that the Bureau did not have discretion and thus didn't have to go through Section 7 consultation according to the Endangered Species Act. The court, the Ninth Circuit, in the 11-0 decision said that actually Judge Wanger applied the wrong standard, that it turned on whether the agency has any discretion, not the degree of discretion in the action. So concerning here was two articles. Article 9 applies only to the quantity and allocation of water. It doesn't refer to other provisions such as renegotiation of the contracts. And the court also mentioned that the Bureau could have mentioned a different pricing scheme or timing of deliveries that would better protect the Delta smelt. And then also referred to Article 2, in which the pertinent language is that renewals may be made for successive periods of 40 years. And the court noted that it's may, not must. Therefore, the Bureau does have discretion. And because the Bureau has discretion renewing these contracts, it must comply with Section 7 of the Endangered Species Act in order to better protect the Delta smelt.
So, in summary, thank you, Adam. That was great. It sounds like a lot of detail and a lot of nuance for the non-water lawyer wonk, which is me as well. But it ultimately comes down to renewal of long-term water contracts. So this was all related to the biological opinions that were originally done in, 2004, 2005, then redone in 2008. In this case, these two clusters of long-term water contracts that were renewed by the Bureau, the issue was whether or not the federal government had to consult with the fisheries agencies on Endangered Species Act issues. And the Bureau had been arguing that it really didn't have discretion with regard to renewal, that it had to renew these contracts for a 40-year period, and that it wasn't really changing anything. The terms weren't changing. It was basically just extending the date for another 40 years. Judge Wanger pretty much sided with the Bureau and the water users. And now the Ninth Circuit has, in a unanimous decision, overturned another one of Judge Wanger's cases. So we're not quite sure what the effects are, because the Ninth Circuit in this case has basically remanded now back down to the district court to figure out all the details. What do we do now with the Endangered Species Act issues? But it adds another layer of uncertainty with regard to biological opinions, long-term water contracts that have to rely on those biological opinions for extensions. And the issue of just extending a contract for another chunk of 40 or 60 years without changing terms didn't seem to resonate with the court. The court actually said, not only did you have discretion not to renew the contract, but you could have in the contract changed pricing terms, pricing timing, deliveries, all things that could have significant impacts on biological resources and fisheries, and therefore there was something that you had to go
just to go a little bit further. So in 2004, 2005, the Fish and Wildlife Service came out with biological opinions that said that the Delta smelt would not be jeopardized by operations of the CVP. And the Bureau did reach out to the Fish and Wildlife Service asking, basically what their position was in renewal of the contracts. The Fish and Wildlife Service basically sent letters in concurrence of the position that the renewal of the contracts would not jeopardize the smelt. But then in 2008, the Fish and Wildlife Service issued another biological opinion, and that said that there was a jeopardy finding that Delta smelt would be jeopardized by operations of the CVP. And the court, in the unanimous en banc decision, said that the Bureau did not reconsult with Fish and Wildlife after the issuance of that 2008 biological opinion.
Right. And just to put a finer point, and hopefully the last word on this, because I know that time is short, we've reported on this for many, many years now, and I think Phil, as chair of the Delta Vision effort, when we periodically reported on Delta-related cases, did talk about this particular issue, the long-term water contract renewal of these certain clusters of contracts, but it all related back to the 2004-2005 issues. So with that, I will ask if there are any questions or...
Thank you. Phil?
Speculate, if you will, on what the impact of the decision might be on the currently delayed biological opinion, 2008 biological opinion enforcement orders that have created this negotiating committee that's supposed to work out some kind of an adaptive management plan, which we heard about last month.
Yeah, and I tend to steer away from speculation in this area, not only because I'm not an expert, because it's highly sensitive, and I don't think it's yet settled. So I'll give my best guess. To my knowledge, and Adam can correct me if I'm wrong because he's probably more up to date, but on the consolidated smelt cases, my understanding was after the Ninth Circuit issued its opinion back at the district court level, Judge O'Neill, who had jurisdiction over the remand process, had asked the parties to submit briefing on what the effect of the Ninth Circuit decision.
Do you know when those are due?
I think that they were already filed. Judge O'Neill issued a decision very quickly after the views of the parties were presented to the court, and I think in effect he said that the remand would continue absent a further order from the Ninth Circuit actually ending the remand, because the Ninth Circuit in the decision that you're referring to had basically upheld the restrictions that the federal government had put into the 2008 biological opinions, but didn't really issue any order ending the remand. So my understanding is that the remand continues and the CSAMP process that's part of that continues unless there's a further order by the Ninth Circuit. I'm not aware of whether or not there is one.
Second related question, I think it was last week, the State Water Project released a set of documents that are proposed to be an extension of the state water contracts from the year 2035, I believe, to the year 2085. And I haven't fully interpreted them, but it seems to me this is an extension of the current terms and conditions, mostly, sort of. What lessons should the state draw from this recent federal decision? I understand it's a federal court on the Central Valley project, but the notion of long-term contract extensions being a procedural only issue, particularly a 50-year extension, has been substantially undermined, I think, by the circuit court's decision.
Right, and so you've suggested some of the issues that I have only briefly considered, and Adam and I were chatting about some of these. I don't know the answer to that. On that, I surely would not want to speculate. I would assume that DWR in particular is paying attention to not only that set of issues, but other issues. I mean, the long-term water contracts, we understand, have reached a point where they've at least come to preliminary approval of some deal points, and that they're going to do a full EIR on that. It's going to take some time, but I don't know the answer to the questions you posed, but there's some of the issues that I've been thinking about.
Mr. Chairman, just a suggestion. Next meeting, the meeting following, you might want just a legal update on that issue.
Got that, Chris? Good. Any other questions, comments? Adam?
I just want to add one more thing. Relating to the case that just came out on April 16th about the Sacramento River settlement contracts, that's been sent back to the district court on remand. So those contracts are still in effect. No changes have been made.
Okay. Adam, since this is your last time as our intern before us, I just want to thank you for your tour of duty, your service here. You're a very impressive young man, and your ability to grasp technical issues and to distill it down to a report that we can all understand is commendable. So thank you for the service you've provided here, and I hope that you decide as you move forward in your career to stay in water. We need folks like you.
I probably will. Don't worry.
Good. Yeah, well, I hope that we haven't done anything to discourage you from moving in that direction. So, Patrick, you have a question of Adam?
We need more water lawyers.
Yes, we do.
Okay.
Like Adam. Yeah.
It's an alternative to more water.
So thank you.
Yeah.
And you're dismissed.
All right. Thank you.
Next item is our legislative update. Jessica Pearson.